All right. Well, I have a bunch of questions, and I'm actually glad that I had researched the topics that I did given your opening remarks. I know they will be well answered. Some are general, meaning anyone is free to attack the question, and some I will single people out. Okay, well, given that we have two lawyers on the panel, I know that you cannot speak on behalf of the professional affiliations that you hold, such as, say, the Trial Lawyers Association or CBA or whatnot. CBA is Canadian Bar Association, which is not the regulatory body. It's a voluntary association.
Which you're anti-male, by the way.
Now, I was going to ask, can you tell us what their views are on shared parenting?
Oh, can I ever? Canadian Bar Association, like every other bar association in the United States, consistently rebuts any movement to have shared parenting. In fact, in the state of North Dakota, their bar association collected about $70,000 from their lawyer members to put up a campaign against a shared parenting agenda and a bill that was going forward. And in fact, they have lost their nonprofit status because what they've done is illegal. And as far as I'm concerned, the Canadian Bar Association is exactly the same thing. Every time we've gone to Ottawa to try to make submissions on shared parenting or joint custody or any changes, the Canadian Bar Association, who purports to represent lawyers in Canada, they don't represent me, always argue against it. And of course, because they are the CBA, their work is given, is impressive and is accepted, and it's a shame.
Okay, well, it seems that you must have read my mind because this is unscripted, I assure the audience. My next question was going to be specifically for you. Why had the North Dakota Bar Association lobbied so strongly against it? You actually...
Yeah. Okay, well, because in the organization I told you about, Leading Women for Shared Parenting, one of our major mandates is to deal with each state as their House and their Parliament deal with these recommendations. What we do is we lobby the politicians in these states, and we try to get them on side, and we've been very successful. But in North Dakota, which is the example I gave you, the Bar Association was so afraid of losing business, because you see, if there's a presumption of shared parenting, then you start on a level playing field, and they don't want that, because they want to line their pockets. And so that's how it started. And in fact, they were disciplined, and there was sanctions against the North Dakota Bar for doing what they did.
Interesting. Yeah. Okay, so I'm a big guy on statistics and hard figures. I'll have quite a few here. Here's a popular one. 34% of men and 66% of women initiate divorce proceedings. Now, these numbers are for the United States. Firstly, does this hold true for BC, if anybody knows? And secondly, why?
Yeah, absolutely. Women in Canada file most of the divorce proceedings, as they do in the United States. So that's an accurate statistic. And they do it because it's a bonanza. You get tired of your husband, you get alimony for life, you get child support until your kid's about 25 or 26. You get half of the family assets or more. In fact, in British Columbia, we're the province that gives more than 50% more often than any other province in Canada. So all of that is true.
Interesting. This goes for anybody. Do you think that women are incentivized through various policies, through various legislative changes, through perhaps the culture, to make false allegations?
The government of Canada is the Don Juan of the modern world. The government of Canada is the Don Juan of the modern world. You having a problem? Oh, come with me. I'll get you on some welfare money. We'll get you a house. I'll give you this. I'll give you that. Aren't I handsome and good, you know? Can't give you sex. That's probably the only thing that they don't help with. Then, so that's number one. The churches are constantly saying, you know, go out and discover yourself. They didn't used to do that. And so the question was?
The question was, are women incentivized?
Yes, of course.
Okay.
And that can be understood. If you are a personality disordered woman, and the majority of the people I am against are, and that's tragic, then if you say to yourself, my child is the most important thing, the first thing they'll go are little white lies which become bigger and bigger. You know, these people will defend themselves to false claims of sex abuse. It's all to control.
I think one of the problems that I'm seeing with some of the feminist activism in the legal system is that the best way to really think about it is if somebody was lying, would the accused be able to prove it? And what I'm seeing happen is elimination of their ability to do so. So, you know, when you make it easier for people to lie without any questions allowed to be asked, and they can get some sort of a benefit from that, I think human nature tells us that they're going to be incentivizing false accusations.
Mm-hmm. I wrote an article about 3 months ago. I called it Liar, Liar, Pants on Fire, Perjury in Family Courts. Yeah. And did I get a lot of comments and a lot of feedback on that? Because it happens all the time. All the time. And it's an equal opportunity situation. Some men lie about their assets, some lie about their income, but more often women lie about all kinds of things that they say went on in the marriage that didn't go on. I remember one case I had many, many years ago. Dad, great guy, was accused of sexually abusing his 3-year-old daughter. Both mother and grandmother were adamant that this was the case, and he denied it, and I believed him. And I asked him to take a lie detector test. This is about, 20 years ago maybe, Carey? 20 years ago. Asked him to take a lie detector test. I knew that they weren't admissible, and they'd never been admitted in any court in Canada or the United States. We went to trial, cost him a fortune, and the upshot was I managed to convince the judge to take the lie detector into evidence. It's the only one in Canada, was my case about 20 years ago. And having said that, the judge found that, you know, she really believed it happened. So, you know, we can't be too harsh because Mom and Grandma, you know, they were genuine in their belief. Now, the court found it didn't happen, but they got a slap on the wrist because, you know what? Gee, they thought it did, and you know, maybe you got to give them a break. That's the way the court reacts when there's no proof of any child abuse, and there's a lie detector that they admit into evidence, but they still say, gee, you know, it's tough, isn't it, Mom? That's what happened.
This is one more particularly for Dr. Dawn Dutton. So, U.S. studies have found dramatic, unexplained gender gaps in federal criminal cases. We're talking about the same court district, the same offense, same criminal history, same level of offense, and men were found to receive sentences which were 63% longer than women on average. Can you comment on the Canadian side of things, given that there seems to be a paucity of data on this, at least from a mainstreamer's observations?
No, because there's no data. So what can I say? I mean, we can only speculate that it's probably worse. Why do I say that? Well, I think gender politics are slightly worse in Canada. If you look at it from the research point of view, let me give you one quick example. In the U.S., there have been 5 large surveys done that ask people about domestic violence. Ask them, were you a victim of domestic violence? Were you also a perpetrator of domestic violence? Okay. What they find, in a nutshell, is about 80% of people who were victims of domestic violence were also perpetrators of domestic violence. Canada's never asked that question in any survey ever. Just, were you a victim? Thank you, that's all we need to know. And so we don't even know what the facts are in terms of domestic violence incidents, in terms of there being bilateral as opposed to being unilateral. The U.S. large sample surveys say, far away, the most common form of domestic violence is bilateral. It's two-way violence, matched for level of severity. The second most frequent form of domestic violence is female violence against a nonviolent male. The third most frequent form is male violence against a nonviolent female, wife battering. That's the third, and a distant third, I might add, okay? So despite all the inflated statistics that you hear, the actual rate of a male using severe violence against a nonviolent female is about 1%. Still too high, but it's 1%. It's not whatever inflated statistic you hear. So given the fact that Canada falls down abysmally in terms of doing even basic research on incidents of domestic violence, I would hardly expect to find anything of any value whatsoever in terms of researching court outcomes on domestic violence.
George, let me tell you about a story. A client of mine, very wealthy couple, live in about a $6 million house on Point Grey Road. Guy came to see me. He said, we've been kind of living separate apart in the same house, and I'm really worried. Things are starting to fall apart. He saw me on a Friday. Monday morning, I got a phone call from him. You're not going to believe what happened over the weekend. I said, what happened? He said, well, I was on the couch, and my cell phone or text or something came off, and I was sleeping, and my wife went over and looked at what the message was, and yeah, I got a girlfriend. We've been separated in the same house for 2 years now. She came over, and she bit his nose almost off his face. He pushed her back, and so she had bruises here and here. The police came, they took him down to the lockup in Vancouver, VPD lockup, and they put him in jail, and they charged him with assault. She had 2 bruises on her arm, consistent with what he said, that he pushed her away, and I didn't see him, but about a week later, he brought in photos of his face. It was unbelievable. I've never seen anything so vicious in my life. Now, he hired one of the top criminal lawyers in Vancouver, and he managed to get the charges dismissed, but he spent 2 nights in jail over the weekend. That's what happens.
I got a better one. Since we're swapping case stories now, I actually wrote this one up for the National Post, and I checked out all the background on it because I knew it was going to be published. A guy in North Vancouver whose girlfriend puts a knife in his stomach, phones the police, and they show up and arrest him. He's still got the knife in his stomach, and they arrest him.
This was going to dovetail...
With a knife in your stomach? Oh, well. Yeah.
This, in fact, was going to dovetail quite well with my next point, that according to a study from the United Kingdom, police threatened 47% of male victims of intimate partner violence with arrest. These are the ones that the police actually threatened them and said, we will arrest you. Yeah. Police outright ignored 35% of male victims, and 21% were actually arrested instead of the female perpetrator.
Right, and you know, there's Deborah Capaldi did this really marvelous study in Oregon, the Oregon Youth Project, longitudinal study. So they're following couples who they know are bilaterally violent. And what happens is 18 months after they've been followed or whatever, one night the violence gets slightly more severe than it has been in the past. And so somebody phones the police, either the woman phones the police or the man phones the police, doesn't matter. They show up, and 85% of the time they arrest the man. These are couples that have been traced and know it's bilaterally violent. They know how much violence has gone on in the background. It's even presented to the police that way, but they arrest the man.
Is anybody surprised to hear this?
One of the things that really distresses me is that in the court of public opinion, you rarely hear just the word violence. It almost always has the word male in front of it. And that's the way people are now looking at violence between individuals. It is always an example of male violence. And actually, I was really disgusted. I mentioned the Brock Turner case while I was speaking earlier. To see a picture of Brock Turner put next to Omar Mateen, I think his name was, they actually put their pictures next to each other and said, different symptoms, same problem. It's hypermasculinity, and these are examples of male violence. And I think we need to just look at violence as violence, and it comes from both genders. That word in front is a disgrace.
Right, and New York Times had an article this week comparing wife abusers to terrorists. It's all power and control. And somebody wrote to me, it's power and control. I said, what isn't power and control? How about drafting laws? Is that not about power and control and fear? anyway, they were making this, in my view, somewhat unfortunate comparison between the two.
I think this leads us right to the Gian Ghamouchi case. I wrote 4 articles because there was so much to say. I couldn't just write one. I wrote 4 articles 4 days in a row. And I was just stunned that the Crown Counsel Ontario took these charges, brought these charges against him based on the testimony of these women that was so inconsistent. They'd lied about so many things. They'd hidden so many things. They had conferred and discussed their testimony. And of course, as you know, Diana, it all came out in court that they were writing 5,000 emails between 2 of the female witnesses. And the poor man, I mean, I have no sympathy for legitimate, abusers, people that rape women and sexually molest women. No use for them at all. But when I saw what happened to him and the ruination of his career, I was shocked. And like I said, it took 4 articles to get it out of my system.
It's a very serious problem. A lot of people wanted to have the women charged with perjury, which of course is complicated because you have to prove that they had the intention. They now have the presumption of innocence, basically, right? But one of the big problems with this was that all of the allegations that he was tried for in court were published in the media. So it became impossible, actually, if there had been actual victims, let's say maybe there was, it became impossible to distinguish the real ones from the false allegations. And that's something that I think is really important to address when journalists decide that they're the cops. And that I don't think that they realized it was going to go to an actual courtroom. They were satisfied just to destroy his life, which is another problem. But this, perjury, I think, is something that you need when you have an example of a woman who sat in a courtroom and said, yes, I misled the police, and admits she lied under oath. That's the 3rd witness. That something happens. Because you can't actually have a courtroom where people feel like they can get up and lie and never be punished for it. That's, I think, a growing concern that I saw from that case.
It's all about political correctness. The Crown, this high-profile CBC on-air talent, the allegations that were made, and gee, if we don't bring charges, then we look like we're not strong enough, we're not fighting, we're not trying to help women. And I blame, in fact, I said this in my article, the lawyers in Ontario who took these charges and proceeded with them.
Now, not to go into this too much, but I used to practice criminal law in Saskatchewan. And over there, it was the Crown prosecutor's policy to take any domestic abuse allegation and go all the way until trial, regardless of the facts and regardless of a recantation even from the victim. Are there similar such policies in BC? And if so, what is the practical result?
Well, the Vancouver Police Department used to talk about zero tolerance, but the Vancouver Police don't lay the charges. The Crown in British Columbia lays the charges. And so I think there's a little more discernment. My husband is a 30-year veteran of the Vancouver Police Department. And I think we're better served here. But in other jurisdictions where the police actually lay the charges, some of them lay charges that can't stand up in court. And it takes the Crown to make the decision. And in some jurisdictions, they don't do that.
Interesting. Now, I was going to ask, I have another, oh yes, here is one. It's one for Carey in specific. Now, judges are bound to consider allegations of domestic abuse, even if they aren't yet proven in a given court case. Some American lawyers have been caught instructing their clients to accuse their husbands of abuse, the client's husbands, which guarantees a rubber-stamped restraining order in order to receive child custody. Has there ever been such a similar drive here, or are judges more discerning?
Every day in every family court across the country.
Okay, that's quite...
You know what the real dilemma is here, though? What happens, the guy gets charged with some kind of minor assault, and he goes to a criminal lawyer. And the criminal lawyer says, I know you didn't do it, or it wasn't like it says, but why don't you just agree to a Section 810 peace bond? And they all say, no problem. But guess what? You should never agree to a Section 810 peace bond, because that peace bond follows you every step of the way in family court. I had a guy come to my office, new client wants to hire me, and he told me the whole history, and he said she made an allegation of assault, and I hired a criminal lawyer, and he told me I should just agree to an 810 peace bond. And I said, are you out of your mind? And he said, well, that's what the criminal lawyer told me. And I said, well, the criminal lawyer doesn't practice family law. I said, in a criminal setting, that may be fine. But if you're involved in a family court and you agree, because that means you're saying, mea culpa, I did it, but I don't want to really go through the criminal system. Never, never. Tell your lawyer that you'd rather, this guy should have just gotten on the witness stand and told the judge what happened, but instead, his criminal lawyer talked him into an 810 peace bond. Don't do it.
Do you find a problem with peace bonds being granted and then women forcing the guy to violate it by putting themselves within proximity?
Oh, sure, all of that. But the worst thing is they follow you. So you have a case, you've got a family law case that you know meanders through the court system for 3 years, and every time you walk into court, that lawyer for that wife says, he assaulted her, there's an 810 peace bond.
So I'm going to read a short paragraph, and I would like some of your thoughts, if any. These stats are from Dr. Dennis Hines, Research Assistant Psychology Professor at Clark University, and a fellow at the Family Research Laboratory and Crimes Against Children Research Center at the University of New Hampshire. It was investigating what happened when men called hotlines for victims. And it was found that when men are being abused and proceed to call domestic violence hotlines or shelters seeking help, it included the whole bunch, 64% of them were told that they only helped women. And 32% of them were, 32% of the callers, of the men, were referred to batterers programs, meaning they were automatically assumed to have, I don't need to explain it. And only 8% of those who made those calls classified them as very helpful. 16% of the people at the hotline dismissed, I should say this with better zing here. 16% said the people at the hotline dismissed or made fun of them. What are your thoughts?
I'll take that one on because I know Denise's work. Yeah, I'm actually at a couple of things there. This was actually the first study that was done on battered men. Okay, the first study after 40 years of research on battered women. And these guys had a very high incidence of PTSD and physical injuries. A lot of them had been physically injured. And they were told when they called for help that they were the real batterer. Okay, that was the first thing. So on top of everything else, they get this label put on them. By the way, in the research on domestic violence, it's common to use this term batterer all the time. In fact, if you look at the composition of the assaultive groups, very few men in there have actually battered anybody. And maybe 10% of them actually did anything that would constitute battering, which I would think would be to commit severe violence against your wife. Most of them are in there for something just far less serious than that. Also, this whole issue, goes to how we think about domestic violence. And I mean, I've done a couple of things on this in terms. I wrote a book called Rethinking Domestic Violence that showed really how the gender paradigm had deeply infiltrated into our minds in North America. So Susan Sorensen, for example, did a study in Los Angeles where she had a little sort of domestic violence scenario, and she played around with aspects of it, like who did what to whom. And she experimentally changed whether it was a male or female that was the perpetrator or victim, and how serious was what was done. Was it hit or strike, or was it something less serious, etc. And she counterbalanced all these things, so there's equal numbers of all of them. And she puts it out to a telephone survey of about 5,000 people, Hispanic, English-speaking, African-American, across the board. And universally, with everything counterbalanced, male violence is seen as more serious than female violence. Now, you can say, okay, if a man punches a woman, maybe it's more serious because he's bigger and stronger. But we're talking here about things that are not even violent. Like if a man asks a woman where she's been, he's being controlling, and he's probably an abusive male wanting to monitor all her whereabouts. If a woman asks a man where he's been, No problem with that. So everything is perceived differently. Everything, not just the violent end. And when you counterbalance everything, the public thinks that male abuse should be treated with a criminal justice solution. Female abuse, not so serious, okay? And actually, you know, there have been studies done, much larger sample studies than Denise Hines' work, that shows that males actually do suffer psychologically from domestic violence, equivalently to females. In fact, one of the samples used was the National Violence Against Women survey in the U.S. I wonder how they ever got any men to respond to that, but they did, and they balanced it out and found
More
this is
men
what
than
happened.
women commit suicide after separation.
Yeah, just, okay, just one other really quick thing. I mean, most people are sort of familiar with the risk of spousal homicide with relationship dissolution. What you might not be familiar with is that men are 18 times more likely to kill themselves than they are to kill their wives with relationship dissolution. 18 times more likely. Now, they're both low numbers, okay? It's not frequent for anybody, but the point is that the overwhelming aggressive impulse for men is toward themselves.
You mentioned just being asked questions being considered violence. I think the term for that is coercive control. This is a concept of violence that was being introduced. That's the kind of thing I try to watch for, too. And there's a reader at law in the UK, excuse me, her name's Helen Rees, and hopefully she finishes this book, is writing a book called Violence to Feminism, and it's about the changing definition of violence and what that means. And I think that kind of leads into a question of mens rea as well, in terms of, is a man guilty of something? Well, you have to have the intention of committing a crime, and with violence and to some degree with rape now, we're getting to a point where a man can't actually know he's committing a crime because there's no intention there, and the definition of that crime is changing so dramatically to make everyday life experiences and expressions of thought to be some form of violence. Very scary definition.
Before we break, and I'm not saying it's now, I don't know when it is, I'd like to make a
Soon.
quick comment.
It's pretty soon. It is actually not that soon. We still got a good 20 minutes. Well, now, here is one. So this is from the University of Michigan Law School. It's from one of their research papers. I can, of course, share the sources later. It concludes, female arrestees are also significantly likelier to avoid charges and convictions entirely, and are twice as likely to avoid incarceration if convicted. Now, is there any data to support the same conclusion here in Canada?
Yeah, Grant Brown's research in Edmonton. Grant Brown looked at every step of the criminal justice system in Canada, from arrest on through to conviction, et cetera, and found males were far more likely to be processed to the bitter end than females were at each step of the way.
Now, since we spoke a lot about divorce, let's talk about prenuptial agreements. Broad question, why are they so hard to enforce?
Well, it's because when you enter into a prenup, presumably you're at the beginning of a relationship. And at the beginning of a relationship, you don't really have a claim on your partner's property. You start fresh, he's got property, she's got property. You haven't earned anything, you haven't been together long enough. So in the beginning, when you sign a prenup, they're fair and they're square. But what happens, because of Canadian law, is that as you have a longer relationship, the fact of the relationship alone gives you certain rights. And if you have kids, it escalates quicker. And if you have a stay-at-home spouse, again, even quicker. So what the courts say, okay, that agreement was fair when you entered into it, when you first started your relationship, but now she's been a stay-at-home mom for 10 years, they've got 3 kids, everything's changed, we throw the prenup out. That's the way it works in a nutshell. What I do now is I tell my clients that a prenup is probably pretty sound for about 5 years. You can count on it. And what I do now is, instead of saying he keeps everything as his and she keeps everything as hers, when I have an imbalance where we have say a wealthy husband and a not so well-off partner, spouse, I say to my client, look if you want this agreement to stand up, I'm going to put right in here now how much you're going to give her. So let's say this, you keep all your stuff, but if the marriage lasts 2 years and under, you're going to give her $25,000. If it's 4 years and under, you're going to give her $50,000. If it's 5 years, you're going to give her $75,000, and we go up until we top it out about 10 years. And I said, that way, if she goes to court, you guys already agreed. This is what she gets if the relationship lasted 10 years. And a judge will be far less likely to throw that agreement out where you thought about it ahead of time. You said, hey, if it doesn't work out, this is what you get. Now, I just negotiated one right now, and I got an email from the lawyer acting for the woman, and he said to me, yeah, I got your agreement, and we're looking at it. And by the way, it's a little light, but she'll probably sign it. And I think that she wouldn't sign it if it gave her nothing. But because we actually give her something so she can see what she gets after 2 and 4 and 5 years, they sign them, and they're more likely to stand up.
That's the classical myth. The thing to look at where the gender matter comes in is when you have a judge sitting on the bench facing two different arguments as to what's fair. And if I could afford it, I'd do a survey, and I would almost guarantee that fairness is more often what the wife's lawyer says it should be, and not the husband's lawyer.
Well, that's natural, because husband wants to pay as little as possible, and the wife wants as much as possible. But I've done 2 cases in the Supreme Court of Canada on men's rights.
That's not what I meant at all.
Well, what did you mean?
I'm simply meaning that the person who's going to define the word reasonable or fair is the judge. And he's going on his own innate education and feelings. And I say that the mother preference is alive and well, the bias is in society, and that judge, woman or man, is going to, almost without knowing it, move towards the mother's definition. And probably to the point, yeah, I think it's unfair, therefore, sir, you now owe her money.
I don't agree with that. I don't agree with that, because there's so much case law that tells you what's fair. If it's a 2-year marriage, this is fair. If it's a 5-year marriage, this is fair. But I've done 2 cases in the Supreme Court of Canada. Both of them were men's rights case. First one was about an agreement. Husband and wife separated. They signed an agreement. Wife came back 2 years later and said, I don't like the agreement. And by the way, I didn't mention it before, but he beat me continuously through our 25-year marriage. We went to trial, and I was stunned, but the trial judge bought it. Hook, line, and sinker. She'd never mentioned it before. She had no bruises. I had all of her kids come on the witness stand. They were all adults. Ever seen any bruises on your mother? No. But she said that her husband flung her across the room, that he beat her senseless, and the judge bought all this. So I went to the Court of Appeal. So in the trial setting, you've got 1 judge. In the Court of Appeal, you got 3 of them. I had 3 male judges. I said exactly to them what I said to the trial judge, and they thought it was nonsense. And they said, overturn the whole thing. Unfortunately, she went to the Supreme Court of Canada. And what we've got is a feminist judiciary there. And you named Madam Justice LaRue DeBay. She wasn't there, but we've got all kinds of others, Rosalie Abella, I could go on and on, naming the feminist judges in the Supreme Court of Canada. And the judge agreed, and he had to pay his wife another $1 million. Had another case with property division in the Supreme Court of Canada, went to the trial. Trial judge said, look there's a lot of debt here. And so, wife, you're going to have to pay half. She appealed. She went to the Court of Appeal, and the Court of Appeal said, oh, no. She's a wife, and, we can't make her pay all this money, even though it's legitimate family debt. And in this case, we appealed. never expecting that we would get a fair deal out of the Supreme Court of Canada, but we did. And the Court of Appeal, Mr. Justice Bastarache, said, it's not fair. If there's debt, then they both have to be responsible for it. But as I said, the British Columbia Court of Appeal said, no, husband's gonna walk and take all of that on his own shoulders. So, it's difficult to predict what's going to happen, and when it comes to money and agreements, you don't know. But there are precedents and there are agreements that say that, what's good for the goose is good for the gander. Unfortunately, that doesn't happen in parenting.
Now, here's one for everybody. Presumption of innocence. Why should the layperson care about this concept? Why should they be concerned of its slow erosion throughout recent years? But also, at a fundamental level, why should they care about this concept? Why should this be held dear to them, if at all?
It might be them someday.
Well, I think it's harder to prove a negative, for one. So when Marie Hennon actually put this really well in an interview with Peter Mansbridge, she said, in terms of criminal charges, when you have the power of the state moving against you, there has to be something to balance the scales. So you've got an individual with limited resources. In the Ghomeshi case, he had fairly good resources, but in the majority of men's charges, they don't. And they're facing a police department that's operating on a budget provided to them by the people, by the state. So the power imbalance in a courtroom is very, very, it's just huge against the accused. And so the presumption of innocence in part is to offset that imbalance. But, on top of that is just, it's easy to make an accusation and very difficult to prove that you weren't somewhere in a lot of cases, or that, when nobody was watching, you didn't do something, that it would be a lot easier to provide evidence that it did happen. And so we need to, again, just balance the scales there.
Mm-hmm. I have a lot of passions, but one of them is the wrongfully convicted. And I do a lot of writing about people in Canada and the United States who have gone through horrendous trials, who have been completely innocent and have been found guilty and have been sentenced to, more often, life in prison. A number of them have actually been executed in the States, where they have the death penalty. And these cases are just unbelievable. And mainly, it's made up of corruption within the police department, incompetent counsel, junk science. You wouldn't believe how many people in Canada and the United States are in jail because a couple of hairs were said to match hairs that were found somewhere in the crime scene. And they have now completely debunked hair matching in science. You wouldn't believe how many men, they're all men, have been in jail for decades because there was bite marks. And there were experts that said, those bite marks are your bite marks. That's also been completely debunked now in the United States. And I could go on and on and on. The forensic evidence that people say hasn't proved a darn thing. And that is one of my great passions right now. I do a lot of writing on people that are wrongfully convicted. And, the presumption of innocence didn't do anything for them.
Just to tell the audience, break is in 5 minutes. Just two little friendly reminders. Number one, the donation reminders. If you wish to make a donation, please see the fine folks at the back. And number two, the raffle reminder. Right before the break, we will be passing out these pieces of, these small cartons. You can fill up the information. It's in the rear, I believe, unless I misunderstood. They are at the registration desk, yes. So not at the rear, they're actually outside the room. Yes, so heading back, so 5 more minutes. I got a good one. How well has mediation worked out in family courts?
Great, where you have rational people.
The worst thing ever to happen to family law is collaborative law. They say you go to a lawyer who's a really nice person, who doesn't want to go to court, and is going to make sure that this all works out beautifully, and we're just going to meet week after week after week, and you're going to have a lawyer with you. And let me tell you, did another article in the National Post called Collaborative Law, A Wolf in Sheep's Clothing. What happens in these cases is that you've got two lawyers and divorce coaches and all kinds of other people that are making a fortune, and these cases run for 3 years, nothing ever happens. Had a gal that retained me about 3 years ago. She said, I want you on the side because I'm going to do collaborative law. Here she is 3 years later. She might finally have a deal. Just collaborative law is a joke. And they say, you know, it's friendly, and you know, nobody goes to court, and we don't threaten about court. But the problem is, mostly for men, that you get sucked into this process, and it never gets you anywhere, because they're not going to give anything up. The only way to get it done is to go to a courtroom when you finally have had enough of everything being sucked out of you for 2 or 3 years.
Well, here's one for Diana. Hate to go back to this, but what should be our takeaway lesson from the John Ghomeshi trial? The entire media side of the story, not just the legal part of it.
There's so much to say about the lead up to that trial and, you know, the results of it. And the main thing to look at is that a man's life was destroyed. Even if he hadn't gone into a courtroom, that John Ghomeshi's career was over and his public life was over, his ability to even walk around in public with his head held up. And God help him if he tries to actually have a relationship with a woman again in the future. And there's going to always be a threat that a new accuser is going to come forward. I spent a lot of time looking at the role the media played in this, and the reality that this man could never have gotten a fair trial with a jury, as far as I'm concerned. And the beautiful thing that did happen there was that he could walk into, as Marie Hennon said, a courtroom with an impartial judge and get a fair trial. But I really think, you know, as was said earlier, that the charges against him kind of insane, that they, especially the Burrell charge, like we're talking about, like, you know, goofing around in an office resulting in a sexual assault charge. How does this even happen? And I think that the court of public opinion put the pressure on the police to take a man to court over something that really, really should never have ended up in the courtroom. And that's another huge problem when that can happen. Same thing with the Twitter trial, that a man who never made a single threat against somebody could be barred from the internet for 3 years and face a criminal charge, never having actually threatened anybody. That's another case that you have to ask, you know, what is pushing these people to lay charges in such absurd circumstances. And the Ghomeshi one, really, I mean, for all the hype and the hoopla that was in the newspapers and this characterization of him as an utter creep, as if that's a crime, and making you imagine that he must have done all these horrible things by just the spin that was put on it. And that spin was powerful enough to land a man in court. It's really terrifying.
I'd just like to add one thing to that. Not being a lawyer, but you need to appreciate why we have to have rules of evidence. They exist for a reason. And one of the reasons is we only have two systems that protect us from our own human biases. One is science and the other is law. And we have an adversarial process in law where people ask tough questions. Now, the Ghomeshi trial, there were a lot of people just so upset about how the system had really asked all the tough questions of these witnesses. Why would they not ask these questions? Really asked all the tough questions of these witnesses. Why would they not ask these questions before it even got to court? The police never asked any tough questions. Why do they not ask tough questions? Because you always have to believe the witness, the plaintiff, right? Same thing happened with the Duke lacrosse trial. Same thing. These guys were accused of essentially raping an African-American woman who came to dance for their group. They were essentially lynched, everything just short of the rope, on Duke University campus. Every academic group on campus was out to get them. They were showing it on 30 on 30 the other night. There were guys holding signs saying they should be castrated. The prosecutor, whose name was Mike Nifong, one of the few prosecutors whose name has ever become synonymous with a verb.
He's now disbarred.
To be, he was subsequently disbarred. He tried the whole case through the press before he even tried to interview one of the witnesses. Subsequently, they found out that the witness had DNA from 10 men, none of whom were present, and none of whom were on the Duke lacrosse team. That when you looked at cell phone records, it was only 3 minutes when it was even possible for people to have an opportunity. That if you matched the cell phone records together, the perpetrators and victim weren't in the same place at the same time. The case fell apart, in other words. And it fell apart because there was good defense lawyers and rules of evidence, but they were absolutely ready to lynch these guys, and it was all just based on stereotypes. They're white athletes, and they were taking advantage of African-American women, and we've seen it before, and here it is again. Well, stereotypes apply to all groups, including white athletes. A stereotype is a stereotype. It doesn't matter what group it is. It just means you're jumping to conclusions about whether this group is innocent or guilty, and that's why you have to have a process in place.
Great answer. One last question. Anyone may answer, though I believe the professor would have something to say, given that the nature of his work involves looking at the long historical view of things. Are things getting better?
From when? What's the baseline
Say
year?
Baseline 1950 and on.
Okay, things are going through a very circuitous route, okay? In terms of, I can give you a quick history of domestic violence. Early 19th century, Teddy Roosevelt got up and said, let's have whipping post legislation. Let's give the guys a taste of their own medicine. They voted on it in Canada, US, and Britain. A whip for wife assault. It got voted down everywhere except 3 US states, the closest to us being Oregon. It was used disproportionately against African-American men when it was on the books for 40 years. So, yeah, better than that. Then it took a big swan dive, and everybody figured, well, family violence, let's just send in psychologists and social workers to solve the problem. So there was no more criminal justice solution. That didn't really work very well either. And then subsequently it came back in the 70s where you needed a criminal justice solution. There were a couple of high-profile cases where police were sued for not acting on behalf of a battered woman. And then, of course, the whole thing was politicized. So it became a political definition of domestic violence. It's happening for political reasons. It's male violence against women. We were taught to think of it that way. That appealed to the political right because it was family values. It appealed to the political left because it was women's rights, and nobody opposed it. And the political view just shot through, even though it's completely undermined by the data, which say it's not that way at all.